Hi everyone, this is Dimitris Koulafetis, and during this video I will be following up from my legal analysis of Section 29 of the Land Registration Act 2002. In my earlier video, if you watched it already, I explained the definition of of what a registrable disposition is under Section 27 of the Land Registration Act 2002. And I also explained the title of Section 29. A registered disposition is a disposition that was previously a registrable disposition. A registrable disposition arises by a disposition. Disposition is a conveyance, a transfer, creation of a registered disposition, a creation of or conveyance of the legal estate in the registered land. Registered land is already legal in itself since it's registered. It cannot be equitable. Equitable land, equitable and equitable estate under Section 3 of Land Registration Act 2002 cannot be registered. Therefore, it is registered land, it's legal, and multiple estates out of that, multiple legal estates out of that registered land, as well as multiple equitable estates out of that land, may be created. However, any disposition that is not, that falls short of the legal requirements and ends up not conveying a legal estate, like an equitable mortgage, an equitable lease, equitable charge, and other interests, will not qualify as a registrable disposition, and therefore is not going to be able to is not going to be capable of being registered as a registered disposition. However, it can be registered by notice, so as to be protected by notice, but that does not guarantee the validity of that interest. It only guarantees its priority against subsequent interests, against subsequent, registered dispositions, because it wouldn't need, according to Section 28, a notice is not needed for an interest to be protected from subsequent interests that have failed to promote themselves to a registered disposition, because they were never made to be a registrable disposition for many reasons. Either because a legal estate was conveyed, but it never registered. A legal estate was conveyed, therefore there was a registrable disposition. Let's say that the purchase of a land was bought by a buyer. A legal estate was conveyed to him by deed and everything. All the requirements of the law were followed. However, he failed to register his disposition according to Section 9, and therefore benefit from the legal effect that it will have with regards to previous estates, previous interests that are non-registrable dispositions. Therefore, or another way that an interest and not a registrable disposition that could be later on be a registered disposition by virtue of registering this registrable disposition against the title of the land be created, would be the creation of an equitable right, an equitable interest, an equitable estate in the first place. That will be by not following the formalities of the law, but following the formalities, because since we're talking about the law of real property, and there needs to be certainty within the real estate market. Equity recognizes only certain ways, a predetermined set of propriety rights that can be actually equitable. So not every way in equity, not every way could be considered making an equitable estate, creating an equitable estate. There are certain formalities that need to be followed, even in equity. And having talked about these preliminary matters in relation to Section 28, I am now proceeding to explain in more depth the effects, the impact that a registered disposition has. Section 29 deals with estates, and estate is an ownership. Section 30 deals with charges. They both could qualify as registrable dispositions by virtue of being a legal estate or a legal charge. Charge could be a mortgage, could be a charge. It's a term that's used alternately. And they are both property rights. Section 27 includes the transfer of charges and the creation of charges, since within its meaning, and they are capable of basically they are a legal estate has been conveyed by virtue of this charge. When a charge is being made, what I want to say is that a legal charge, legal mortgage, this is the creation or transfer of some kind of an estate in land has been conveyed, and that's what counts according to Section 27, for there to be a creation or transfer of a legal estate in land, in that registered land. So Section 29 says that the completion of the disposition, that means when it is registered, and therefore it can take effect as a registered disposition, has the effect of postponing to the interest under the disposition any interest affecting the estate immediately before the disposition whose priority is not protected at the time of registration. That means that when there is an interest that may be registered by notice in order to be protected. It's not a registrable disposition, though. We already been through that, and we already explained that. When it's not protected by notice, then the holder of the registered disposition, when at the time of registration, will take precedence, will actually postpone the priority of the earlier interest. This is why it is of instrumental importance that persons that hold registrable interests, interests that are not registrable dispositions, and therefore they cannot qualify as registered dispositions according to Section 27 and 29, to protect their interests by notice on the registered. So they make themselves identifiable in the land charges register against a later registered disposition of land that will potentially displace their priority, because it's not an equity. Registered disposition is a legal right. Now, if it was an equity, it was a later equitable interest, the previous equitable interest would not need to be protected by notice, because the maxim that when equities compete, the first in time prevails falls perfectly into place under these circumstances. We're talking about two equitable interests attaching to the property, and the prior is there first in place. Therefore, no notice needs to be recorded. However, in summation of this video, I need to make reference to the to exceptions of exceptional interests. I need to mention exceptions of interests that are not registered dispositions. They are not capable of being registerable dispositions in the first place, and therefore registered dispositions. But they are not capable of being protected on the land charges registered by virtue of a notice. The Parliament has not given them such a power, such a right. Those interests are overriding interests that override, and Schedule 3 of the Land Registration Act 2002 makes reference to them, since they deal with dispositions. They deal with registered dispositions and not first registration in land, and therefore the list is different, since there is someone that has given valuable consideration and has purchased the property, and therefore the law must afford him a protection, and equity must afford that transaction a protection too. However, it would be different, and it's very important, and I will conclude discussing this matter. It's very important that in order to bind, in order to have a priority against the previous equitable interests that are not protected, the registered disposition must be made for valuable consideration, and it must be in good faith. It must be made for valuable consideration. If it's not made for valuable consideration, it's, for example, a gift, then it will not bind the prior unprotected equitable interests. This is Dimitris Koulafetis. In my next videos, we're going to analyze more the Land Registration Act 2002, Section 29, and related sections. Thanks very much for watching.